I'm Larry Menti. Welcome to Another Thing. The national news is filled with police activity videotaped by citizens on their smartphones. It has long been held that those recordings are protected by the Constitution. But a recent ruling by a federal judge in Philadelphia has changed all of that. The ruling that the person videotaping must state their purpose to police, and if that purpose is not either a protest or a challenge, it is not protected by the Constitution, and police can shut it down. That controversial ruling sent shockwaves across the country. Kolodziej now reports from Philadelphia. Ellen.
Thank you, Larry. Now, most people know they have a First Amendment right to take video or a picture of anyone on a public street. Now, that can be an average person, a drug dealer, or a police officer. And that's why a Temple University student took a picture of police officers here on a Philadelphia street. He thought he had a First Amendment right to do that, but a federal judge said he did not.
Being able to actually videotape or record the police is an essential part of how we hold police accountable today.
In 2013, Temple University student Rick Fields took this picture of Philadelphia police officers outside a house where they were making several arrests. One cop told Fields to stop taking pictures because he was allegedly blocking the highway. When Fields refused, they handcuffed him and issued this citation. The ACLU sued, but federal judge Mark Kearney ruled that civilians have no First Amendment right to record the police unless they're doing so for the sole purpose of criticizing them.
I worried that the ruling was going to create a lot of confusion, and we've actually heard from a number of people who are confused about what it means, are worried that it now means it's illegal to record the police, which is not the case. It's still not a crime to take photos of the police, and you can't be arrested unless you're committing a crime. So I just mostly worry about the confusion and the message that this sends to the police and also to people who want to pull out their smartphones and take photos when they see the police interacting in public.
Molly Tack Hooper is a staff attorney for the ACLU of Pennsylvania. She says they're appealing the ruling and they're confident they'll win because no other court in this country has ever said a citizen has to first tell officers they're taking pictures to use for criticism, and that people should absolutely keep recording the cops to keep them honest.
Recording police interactions is one way that ordinary citizens can monitor how the police use that tremendous power.
We reached out to the Philadelphia Police Department for a comment, but we never got a response. In a 2011 memo, former Philadelphia Police Commissioner Charles Ramsey told his officers that average citizens do have a First Amendment right to record their actions. Reporting for Another Thing, I'm Kolodziej.
Thank you, Ellen. We continue our conversation now on recording police activity and whether that is protected by the First Amendment with Greg Bordelon, who is a lecturer of legal studies at Monmouth University. Welcome back. So you have this ruling that says that now if you're recording police activity, you have to state that it is either a protest or you're challenging the police activity. Is that going to stand up?
Personally, I do not think it will. There are stakeholders in this litigation that have already said that they will appeal to the Third Circuit, which comprises New Jersey, Pennsylvania, and Delaware. The touchstone that I think is the concern in this case is that it places the onus on the speaker to determine whether or not what they are attempting to convey is protected or not. And normally, the police should say, as representatives of the state, you can or cannot do this. So I think that the Third Circuit is going to pick up on the fact that the district court judge said this is not speech, because that's what happened. The district court judge essentially said this is not speech, therefore you're not protected by the First Amendment. And that's why it was effectively a ruling in favor of the state. I firmly believe that the Third Circuit Court of Appeal is going to overturn that and say that this is protected speech. When you are not impeding on the police's right to engage in a lawful arrest, you're far away, you're distant, you have an inherent right under the First Amendment to record that.
Can I record anything? Am I allowed to record anything that's happening in public as a First Amendment right?
So you know what's interesting is that this case is an outlier. The First Circuit, which comprises Massachusetts, Vermont, New Hampshire, has two cases on the books from 2011, 2014 that says essentially what you just mentioned. Yes, if you are in the public and you are not impeding on the police's right to do their job, you can record essentially anything. And there is no way for the state to say that you don't have a First Amendment right to do that.
As it stands right now, what are my rights? Let's just say I were to come across something and wanted to videotape it. Do I have to announce that I'm challenging the police on this?
Well, we're not sure, right? Because the nature of our courts is that I would say now, after this Philadelphia city ruling from the Eastern District of Pennsylvania, we do have to announce. But again, the Third Circuit Court of Appeal, if it is going to be in line with its sister circuits, the First Circuit, the Ninth Circuit out in California, the Sixth Circuit in Chicago, will probably overturn that. If they don't overturn it, that becomes the interesting dynamic for the Supreme Court. Ironically, an 8-justice Supreme Court as we have now.
Which you might again have 4-4, although I would think that there are some strict constructionists, constitutionalists on the Republican side that might say, yeah, that is free speech.
Sure, and I don't want to completely say that from a libertarian standpoint, they are going to emphatically say you have an inherent right that is unqualified to tape the police. Obviously, the police, under the Fourth Amendment, have a lot of discretion to be able to perform their job in very, very dangerous situations. So those 2 cases from the First Circuit I mentioned, one was in furtherance of a traffic stop, and the appellate court there was a little leery to say that you had a right to tape. But the facts matter in these cases. In that traffic stop case, the recorder was way off to the side. The police had already secured the perimeter. She was in a parking lot for a public school. I think it may be different, and the Supreme Court may be in an opportunity to frame a protection for the police that says, look, if you are impeding in the police's rights or even making it more dangerous for the police to do their job, the First Amendment doesn't protect you.
Well, let's flip this for a second. What about body cameras? And what about dash cams? Do police have the right to videotape me all the time?
Well, I know that the Obama administration has tried to put forth the initiative to say that we should put money into this initiative. I think it will politically flip the discussion. Whether or not it legally flips the discussion is another question. I think on the legal side, the point becomes moot because then, politically, the police are owning the discussion. And they are then agreeing to be filmed. The filming is sort of an unfiltered way of showing what the truth is, right? You can't spin that. So I don't think that we're going to have litigation if this is adopted wholesale, but I think that's the problem. I don't think it will be adopted wholesale.
You're a constitutionalist, you're a First Amendment expert. You hear something like this, where someone that's filming police activity from a distance, and I've done it before, by the way. I've been in situations where I've filmed police activity, and it was to the benefit of the police, I might add, and I was just recording to see what would happen. If I had to announce in the situation I'm talking about that I was protesting or challenging, I would have to say, no, I'm not. I'm just recording what's happening. And then the police would have the right to shut me down. What is your gut reaction to that? When you heard the ruling and you know the Constitution, do they jive?
So one always looks at, from a professor standpoint, does it meet the test? And the first test for any First Amendment challenge into free speech is this speech? And again, this judge cut it off at the ankles. He said this is not speech because it's not expressive conduct. And I personally believe that's where the flaw is that there are going to be certain categorical things that citizens of this country do, such as filming the police, that really make irrelevant why else would you be doing this. You are doing this even in the eventuality, if it goes on social media, if you convey it to a friend, you're doing this for the purposes of informing the public. That's political speech. That is the highest level of protection. So for this judge in the Eastern District to simply say, we've got this kid in a deposition or in a pretrial motion saying, I was just doing it just to have fun, I think that's irrelevant. I think the Third Circuit is going to look at that and say, no, you're filming the police. Certainly this is going to be a protected form of speech.
Interesting to what you say, if I'm in the media, if I'm a journalist, it would be free speech, right?
Exactly.
But if
By
you're not a
virtue of you being
journalist,
right.
It's not free speech.
Well, and
is
again,
what he's claiming.
A little bit, but that's not going to hold water either, because those 2 First Circuit cases reiterated the fact that in the social media age, it doesn't really matter if you're a journalist. Whether or not you're a journalist relying on free press or you're a layperson relying on free speech. The same thing in the digital age should be the same rights. Whether or not you will go back to your office and write a newspaper piece versus me recording it and immediately blogging it is irrelevant. The First Amendment protects both characters equally.
Yeah, that's a topic for another time. The fact that we're all journalists now, we can we really are. We can record news as it happens.
Exactly.
We can publish news as it happens. We don't need TV anymore.
Right.
Oh, I shouldn't have said that out loud. Thank you so much.
Thank you very much.
Greg Bordelon, lecturer of legal studies at Monmouth University. When we come back, are you ready for driverless cars? You should be. They're here already, and they will be here in mass very soon. We'll talk to someone who is an expert on the topic when Another Thing continues.